tenure on January 16 this year. Okay, may I request Attorney Anama to introduce the 4 applicants?
Yes, Your Honors. The candidates to be interviewed this afternoon are the following. We have Sandigan Bayan Associate Justice Maria Cristina J. Cornejo. Then we have Court of Appeals Associate Justice Apolinario D. Bruselas Jr. And then we have Deputy Ombudsman for Luzon, Gerard A. Mosquera. And the last is Court of Appeals Associate Justice Rosemary D. Kandang. May I request Justices Bruselas, Kandang, and Deputy Ombudsman Mosquera to stay in the holding room while the interview of Justice Corneo is being conducted. Thank you very much, Your Honors. Justice Corneo.
Good afternoon, Justice Cornejo.
Good afternoon, ma'am.
So, may I now request Attorney Cayosa to start the public interview.
Thank you, Justice Gutierrez. Good afternoon, Justice Corneo.
Good afternoon.
We have interviewed you extensively for your application for the same position in 2014.
Yes,
Since that time, are there any significant developments in your career as a jurist that you would want the JBC to take note of?
That's only about 2 years ago, and I don't think there's anything significant. But for cases, I'm not even involved in the PDOF cases because I belong to the 2nd Division. We do not have as yet, but I think there's a new one now coming. There's nothing significant.
Is this accurate? It states here that your caseload is only 3?
Yes, for submitted.
For submitted.
Yes.
But active cases that you are currently hearing or trying?
Active cases, that would be of course, inclusive of all the other justices. But as for submitted for decision, I have only now, one is resubmitted. The other one has just been given last week. So it's about 3 or 2.
So how have you improved since the time that we last interviewed? How has the system in the Sandigan Bayan been improved in order to expedite the trial of cases? I understand that there are more being filed now.
Yes, ma'am. There are more being filed, but you see, ma'am, it all depends on how each division undertakes. We have a regular procedure, as we have. We now are coming up with revised rules of procedure for the Sandigan Bayan, and it has been submitted to the Supreme Court, I think. But we were told to revise some more, so it's back to our office. But I think we're almost done with it until amendments, I think.
In what way do you feel that you're better prepared for the Supreme Court 2 years after the last interview?
Better prepared. I think I'm prepared for the Supreme Court. Because, ma'am, our cases are more, because in the Sandigan Bayan we do trial and then appeal, but more on trial. So we're more in touch with cases. We're more in touch with people. We're able to better understand how these things are being presented. We're able to better perceive the reaction of people because of the trial. That is how I view it, ma'am. It's not more on appeal. In fact, I do not think I've been in the Sandigan Bayan for about 4 years, and more than 4 years, and I've not handled an appeal case yet. More on original cases that are being tried.
As I mentioned, we have extensively interviewed you just 2 years ago, but I just have one final question. How did you feel when a colleague of yours, Justice Ong, I think he was the chairman of your division at the time,
Yes.
when you heard that he had been dismissed from the service?
Personally, how
Yes.
I felt. Of course, I felt hurt because I've not been in the Sandigan Bayan for quite some time when he was dismissed, but he has been nice to me. And ma'am, because you really cannot really know a person that easily, because after hearing, we don't see each other anymore. In fact, we don't talk because I'm busy with my assignments. They're busy. I don't know what they're doing, but I'm busy with my assignments. I really don't.
What would you consider as a learning from that incident? As a learning, or something that you pondered or reflected on as after that incident?
His dismissal? It's not a learning because what the Supreme Court saw in him is different from what I see in him. I saw him as a person. I saw him as a person. I saw him as my presiding justice and my head, the chairman. I saw him as my chairman, and we may have. I think we differed. We may have differed, but I'm always overruled because of Justice Hernandez and him.
Thank you, Justice Corneo. As I mentioned, those were my last questions.
Okay.
And I wish you well.
Thank you.
Thank you. Thank you, Madam Chairman. I have no further questions.
Thank you so much, Attorney Cayosa. May I request now Attorney Mejia to continue?
Thank you, Madam Chair. Good afternoon, Justice Cornejo.
Good afternoon.
You were once a recipient of the Lingkod Bayad Award.
Yes.
What merited you that particular award, and what are the circumstances surrounding that award, Justice?
I really do not know, but I was called by the Supreme Court that I was nominated. And then it said there were several others, and I was chosen. And I asked why was I chosen? You were just chosen. And I'm not really into asking why you chose me. I just felt that I was fortunate that God looked down on me and for probably seeing the kind of work that I did, because I've been in this in the judiciary. From MTC, I stayed in the MTC for 15 years, and then I was promoted to the RTC. I stayed in this RTC for 8 years, and then I was promoted to the Sandigan Bayan about 5 years ago or 4 years ago. I'm not sure.
Justice Cornejo, you were an examiner for criminal law in the 2011 bar exams.
Yeah,
Is that correct?
under Justice Abad.
Okay. Have you seen any improvement from the time that you acted as an examiner for that particular review with the conduct of the Philippine bar exams? And what areas, if any, would you still recommend to be improved with respect to the conduct of the bar examinations?
Because, when I was bar examiner for criminal law under Justice Abad, that was the first time that I think that was the first time that we had this MCQ. So we were very careful because that was the project of Justice Abad, and I think now it's going back to the old style. I'm not really sure about it because after I became bar examiner, I'm not active anymore. I just teach.
understand that once a shortlisted is submitted to the President conducts a one-on-one interview among
Hopefully.
those who are in the short list. No? How will you convince the President that you should be the one who should be appointed to the vacant position now?
How should I convince the President? First, I have to talk to him. And if given the chance, I would explain to him that I've been in judiciary and I started in 1987. And I think I've worked my way. I've been honest. I've been meticulous in my work. As in fact, I was without me applying for it, I won the Judicial Excellence, Centennial Award for Judicial Excellence, and then subsequently I won, without me asking for it, I won for the Lingkod Bayan Award of the Civil Service, and which actually gave me the chance to be promoted. Remember, I was in the MTC for 15 years. I really had no, and I mean, let's face it, you need to have a backer. I really had no backer. I was in the MTC 15 years, and I won the Judicial Excellence, and then when I was in the RTC, I won the Lingkod Bayan Award. All this, I really worked hard, and in everything, it is from my heart. That is true. And the Lord probably smiled down on me.
That was my final question. Thank you and good luck, Justice Corneo. Thank you, Madam Chair.
Thank you so much, Attorney Mejia. May I request now, Attorney Guevara, please continue.
Thank you, Madam Chairman. Good afternoon, Justice.
Good afternoon.
I'd like to ask a question that was relayed through Twitter earlier this morning, not specifically intended for you, but kind of interesting. Do you think judges should be elected instead of being screened by the JBC and appointed by the President?
What do you mean, elected by ordinary people?
Yes, right.
I think they should be selected because for example, the JBC, the JBC's the members are chosen because they have certain qualities that would actually know the kind of person that you are as far as the field, as far as the legal profession is concerned. If you're elected by everybody, by those who are qualified to elect you, everything would come into the picture, like favoritism. You're a member of the family. So many connections. Whereas if you're simply selected by people who are actually placed there for you to actually see you from the legal standpoint, from the fact that you are a member of their profession, I think it's a better choice.
All right. Why not just the Commission on Appointments then?
I understand. I'm not so sure about the Commission of Appointments. I think they are part of. It's more political. Commission on Appointments. I'm not so sure about that, but I think better is the JBC.
Are you saying that the JBC is insulated from political considerations?
That I do not know.
Kindly
But,
explain your answer.
That I do not know if they're politically insulated. But as far as we are concerned, lawyers, particularly those who apply for positions in judiciary, they are supposed to be, and would like to believe that they are politically insulated.
Do you think the judicial affidavit rule is serving its purpose?
I think it is serving its purpose if it is light, not the big cases, because judicial affidavits, you have to include everything, correct? But if you fail to include, it will be subjected to cross-examination, you might forget about it. So I think it would be best to apply the judicial affidavit rule in cases which are not that big.
What is your definition of a big case, Justice?
My definition of the big case, for example, plunder, where several issues, sometimes intricate issues, come into the picture, which do not simply need an affidavit, which cannot really be explained in an affidavit.
Okay. All right. So one of the biggest problems in the Philippine judicial system, especially in the litigation process, is the problem of delay. So can you just give us a couple of specific or concrete measures that you can propose in order to accelerate the civil litigation process?
Civil,
Yes.
as distinguished from criminal
Yes.
litigation. Okay, civil. Excuse me. Are you asking me the procedure, or are you asking me the manner in which these cases? Because you see, there are certain courts, although they observe the procedure, they adopt a different one to see to it that the cases will be easily disposed of.
Well, you refer to anything that would expedite the process to its conclusion.
Okay, the first is if it is a light offense, if it's a claims, civil cases, claims of small value, you do have to determine how much it is, no? You can probably use the judicial affidavits. No, but for big cases, I do not think you can make use of judicial affidavits. And if it is, what else? If it is, the point is you have to be able to distinguish what is a big case from a light case where the amounts involved are different. You know what I mean?
Yes, but Justice, are you saying that there will be a different set of procedure, perhaps, in connection with cases which you consider to be substantial or big, and another set of procedure for probably less than what you consider
Yes.
big or significant?
Is it not a different procedure if you adopt a judicial affidavit? As I said, you may adopt a judicial affidavit if the issues are not really. If the issues are not really complicated, are not really intricate, judicial affidavit.
Anyway, that rule, Justice, is already in place. So, but nonetheless, we still encounter the same problem of delay, notwithstanding the adoption of the judicial affidavit rule.
Okay.
So do you have any other specific proposals by which the length of time involved in litigation, more particularly civil litigation?
So it is
can
already
be
in place. For
shortened?
example, if it is a case that is to be litigated, we lessen. That's one point. You may lessen the period of trial, but that is already in place also.
Yes.
What else?
In other words, we seem to have all the necessary measures in place, but the problem is still the same.
Yeah,
It remains.
Yes, we seem to have the necessary measures. I agree. No, so it would depend on the person, on the persons adopting the measures, on how they are able to adopt the measure to be applied for that purpose, to litigate, to expedite the proceedings.
Ma'am, are you referring to the judges or
Yeah,
to...
probably. Yes. Because when I was in the MTC, when I was in the RTC, I was able to limit it to active cases. When I was appointed to the RTC, there are only very, very few cases that have not been decided, that have not yet been resolved. I think it all depends on, especially if you're the one handling the case. You're only one, no? Except when you're already in the Sandigan Bayan and the Court of Appeals, where there are 3. But nevertheless, you can still reduce it pagka, if it's a higher position, like the Sandigan Bayan, because what we do is we meet and what do we do with this case? Ganyan. That's how we do it in the Sandigan Bayan. But when I was in the lower court, MTC, RTC, I try to expedite. When it's submitted, I do it. I don't waste time.
Yes, Justice, there was this proposal, if I'm not mistaken, 1 or 2 years ago, to amend the existing rules of civil procedure. And in fact, a committee of the Supreme Court was formed specifically to attempt to do that. I think it was headed by then Justice Abad. And one of the main features in that proposed amended rules of civil procedure would be on the trial stage, where all the witnesses for and against the parties litigant will be simultaneously convened with the presiding judge convening everyone and conducting the trial as if it's one big conference. And in other words, all the facts in issue can be discussed in one sitting with all the witnesses being present under the supervision of the presiding judge. In your opinion, do you think this is something that can be workable if adopted by the Supreme Court as a revised rule of civil procedure?
You mean they're going to complete the trial, the case in one day?
Not necessarily in one day, but the intention is to bring all the witnesses together, okay, for or against a party, okay? Both parties, let's say A versus B, then their respective witnesses will be present in one room on a particular schedule, and so forth and so on, so that each party can present his witnesses and the others can immediately rebut whatever evidence is presented by the other side. The obvious purpose being to shorten the period of presentation of evidence.
Number one, it all depends on the number of the witnesses to be presented. Number two, if the number is, if it's a great number of witnesses to be presented, it's not workable. I don't think it's workable. You just can't put them all together. That is why I think the present rule on direct cross, redirect, recross, that would be better, and then rebuttal. If there's a need, because you can waive rebuttal, you can waive rebuttal. If there's no need for rebuttal, you don't need to conduct a rebuttal. I think it is more in order. It's more orderly. It is more. It's more orderly.
Okay. Thank you, Justice, for your answer.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue.
Thank you very much, Madam Chair. Justice Corneo, good afternoon.
Good afternoon, ma'am.
How is your health, Justice?
I lost weight.
Your health?
To be honest, ma'am, I don't feel anything. The doctor said my hemoglobin went down.
Low.
It all started only 2 months ago.
So, are you addressing that problem?
Yes, ma'am. I'm
And
being
also,
treated.
your uric acid is quite high. I noticed that you're quite frail now.
Yes, opo.
The first time I saw you, you were so pretty.
Now no more.
You're still pretty, but you are frail. That's why I'm worried. Something. Okay, Justice. You have been an associate justice of the Sandigan Bayan for more than 5 years already, having been appointed in March. Is it not? In
Opo.
March of
2010.
2010. ano?
Opo.
Now, what do you consider at this point in time? What do you consider as your most important contribution to the court?
To the
To the court, to the Sandigan Bayan?
Sandigan Bayan. Ma'am, because you don't individualize
Yeah.
or you don't itemize.
Yes.
Especially so, I'm a junior member. I'm only a junior member. I've just
Are you
been
still a junior member now?
Opo, ma'am. But I will soon be a senior member
Yeah.
when the six
When
new
the six
justices
new,
come
yes,
in.
justices, yeah.
See, I'm still junior member, ma'am. So with more reason, I do my work as assigned, and then, but I do my work I finish it earlier than the regular schedule po.
So at least in the disposition of cases,
Opo.
you contribute in
Opo, opo. In fact now,
Action.
opo, I may be a junior member, but the chairman assigns to me cases.
I see.
Opo.
Now, what are your thoughts on the practice of some justices and judges of inhibiting themselves from trying cases before them on the ground of pressure or threat they receive from outside?
Ma'am, first, I think it's their choice. Ano po?
Yes.
It is their choice on whether or not to inhibit.
Yes.
But I think you're there. You went there. It is your choice to be there.
Yes.
So you have to accept responsibility. Whether it will be, now nga I have one but I am not inhibiting. I am trying
One
to.
threat or what?
One
You
case.
have one? What is that one?
One case po.
One case.
Opo. But, ma'am, I do not want to be pressured.
Yeah. That's very good.
Sa totoo, I pray. That's true.
Yes.
I pray, sabi ko, tell me what to do. Tell me what to do. Do I inhibit? Because I really do not want to inhibit. Because I said, I came to this court
Yeah.
knowing what you know what to expect from this court. So it all depends on you. Well, I was in the MTC, as I said, for 15 years. There were some pressures, but I stood my ground, and that's why probably I became an RTC after 15 years. And in the RTC, I was in RTC in Makati. I was RTC in Makati, but nobody pressured me because they already know me.
Yeah. You have
Opo.
a reputation already.
Opo. And now in the Sandigan Bayan, nobody talks to me.
Yeah.
Opo.
Because you have a solid reputation. Now, one of the problems confronting the courts, more specifically the Sandigan Bayan, is corruption allegedly committed or being committed by some of its members and other personnel of the court. So, how do you address this problem?
Ma'am, first, as a junior member, I don't take part in that.
Yeah.
As precisely a member of the Sandigan Bayan, the only thing I can do is when we are already called
Yes.
in an unbanked session, and where our reviews are obtained or asked by the presiding justice. Only then, if I feel that it's not in accordance with what I feel about the situation, that I talk. Otherwise, I don't.
So, how do you discipline your staff? How do you
Ma'am,
manage them? Because they say that most of the corruptions are being committed by members of the staff.
ma'am, I only have three.
Three?
Opo.
Bakit? You're entitled to 12, is it not?
I don't know, ma'am, but I only have three. One is my lawyer, whom I brought from Makati.
You have only one lawyer.
Opo, wala pa pong nag-apply eh.
Ay, sus.
Yung isa, my lawyer, she wanted, kasi she's married, she asked permission if she can go to COA. COA po, mas malaki daw ang ano doon. Who are you to stop her?
Okay.
Opo. Tapos, and I have one stenographer and one clerk.
And who help you in the research?
Ako at saka yung lawyer ko. We do it.
Jesus.
That's true, ma'am.
Oo nga. Kaya ka pala nangangayaya. Okay. So what are your views? We go to another point. On the Supreme Court's issuances in certain cases of conflicting views and rulings. And if you will be fortunate to be nominated and appointed to the Supreme Court, what would you propose to minimize these conflicting views and issuances?
Ma'am, what do you mean conflicting views and issuances?
There are cases when the rulings are conflicting.
Yes, ma'am, but hindi po ba what is to be accepted is the majority?
No, even the majority ruling, kung minsan clashes with another majority ruling on another case.
In different
In another
cases,
case.
opo.
Di ba? Even in the Sandigan Bayan, is it not? There are, it happens in all courts. So what would you propose to minimize those occurrences of conflicting rulings?
In the Sandigan Bayan, conflicting
Now in the
views.
court, in the Supreme Court, we are talking about the Supreme Court.
In the Supreme Court, if there are conflicting views,
Yes.
ma'am, if there are conflicting views, but of course they will have to come up with one view. Di po ba?
Oo, pero minsan those two views are still existing.
The views are still existing.
Yes.
But
What would you propose to minimize that?
number one, for those who gave conflicting views to talk, so they would try to iron out whatever is the conflict, and then of course one view would have to be sustained by the rest, and that would be the prevailing view. If it is prevailing view, it has to come out. But the one with a different view can make a dissenting opinion. That would be considered as a dissenting opinion.
Okay, oo eh. Kasi ang lapit ka. Ha? Hindi nila itinag-free lapit. Oo nga eh. Yun nga, to be candid about this is what is called flip-flopping, di ba? The flip-flopping decisions of
Opo.
also. How are you going to address that flip-flopping incident?
You mean they have already decided?
And then another decision.
Opo, they have already decided. Kasi ma'am, I think yung flip-flopping, you mean they come up with one decision and then they
Which is
change it?
contrary to the other decision.
Contrary to the other decision okay. One decision is rendered by the Supreme Court, that is the majority decision in one case. And another decision is rendered by another. Is it a decision by division?
Yeah, they call it flip-flopping.
Opo. Opo.
The same. The same decision. And then the view made in the first decision is totally different from the views in the second division.
But it is still one division that made it.
Not necessarily. Oo, not necessarily.
Not necessarily. And ma'am, hindi po ba if it is made by one division, it is independent of the other division?
Hindi. Yun na. For example, there is a motion to transfer the case to another division, di ba? Yeah. So it happens. So it
there,
happens.
one division rules on this,
And then-
on one
then
topic,
another division
and then
will rule
another,
another point.
and then it will be
Division.
brought on motion to another division,
another division.
and that division makes
A decision which is totally the opposite of the first decision.
okay. And the question is, how do you?
How would you address that? If you are in the court, what would you propose to address that problem?
I think I would, if I ever the Chief Justice.
If you will be a member of the court, imagine that you are already a member of the court.
Opo. How would I propose? Okay,
Yeah, what-
let's just say that I am not just a junior member.
Yeah.
Kasi pag junior po
Sige
eh.
na, senior member ka. Let's pretend that you are
Kasi pag junior po, masyadong ano
Oh,
eh.
sige.
Opo.
Let's pretend that you are a senior member.
Even if, okay, if you're a senior member and it is contrary to the, I think for the people not to be confused on the stand of the Supreme Court, these members, these warring or conflicting members would have to meet and redecide on, because it has to be explained that the Supreme Court would have to take one stand on one matter. Also, I think I would, if I were a member for this one division, I would urge a meeting where we will have to give our views on that particular, why did we arrive at this conflict, and then I believe that it can be resolved if there's a
You will
meeting.
propose that there should be a mechanism
Opo.
to settle all these
Yes,
differences
but
in
importante
opinion.
po, you don't just set a mechanism or certain rules,
Yeah.
but you first have to talk among yourselves,
Yeah, but
opo,
I-
and then come up with a mechanism or a procedure by which you can resolve whatever is conflicting.
Because actually, that is a problem of the court, which affects its image.
Opo,
It has to be addressed.
Opo.
Is it not?
If I were in the court, I would suggest that. Opo.
Okay. Now my last question. Justice Corneo, give us one strong reason why we should include you in our shortlist.
Because, ma'am, you may not know me. I know myself.
Yeah.
I know myself. I've worked hard in the judiciary. I stayed in the judicial, as I said, I'm very proud of saying that I've been in the MTC for 15 years. And I had no backer. I got to the RTC. I won. I really worked hard. And I love the judiciary.
Okay.
I love the legal profession. I was born to it because my father was a lawyer.
Yeah.
My father was a judge. And I remember when he was alive, he told me, if you want to join the judiciary, if you want to join the prosecution, I started with the prosecutor's office
yes.
in Manila. If you want to join, don't come running to me if you have any problem. Pag talagang hindi mo na ma-resolve, tsaka ka lang pupunta sa akin. That's how he trained me. And I'm just sorry, he's no longer alive when I became a judge.
Okay.
I know I can contribute. This is the final step. I've gone through MTC, RTC, now Sandigan Bayan, and I'm proud of it.
Okay. On that note, I have no further question. And I wish you luck, Judge Cornejo. You take care of yourself. You were so pretty before,
Thank you so much, Justice Lagman. And now it's my turn. Justice, let's go back to the case of Napoles involving Justice Ong. Did you read the decision before you signed?
Which po?
The decision concerning the Kevlar case.
Yes po.
Did you read it? Did you read it?
Opo. But
Okay.
I really don't
before you signed, are you sure?
Opo, opo.
You were not pressured by Justice Ong,
Oh, no. They cannot.
by Justice Hernandez?
No.
Well, in the decision itself, it appears that there were 6 corporations owned by Napoles. And these 6 corporations were the ones who supplied the Kevlar helmets, found later to be of inferior quality. And that was the reason why the people behind the 6 corporations were charged, including the husband of Napoles. Remember? Remember? These are the facts of the case. And then, of course, the Navy people, Navy officials who received the Kevlar helmets paid all the 6 corporations. But the money, if you remember, it is in the decision of Justice Gregory Ong, the money or payments went directly to the account of Napoles. And that is a very glaring evidence that it was Napoles who supplied all these Kevlar helmets, which were of very, very inferior quality. Diba? These facts are in the decision. Yet, it was only Napoles who was acquitted, although the money was received by her. Documented yung under her account. And these 6 people who were allegedly directors of the 6 corporations were all convicted, but later on, probationable. And so they were released. But, I mean, you are so intelligent, Justice. Why did you not dissent? A while ago, you said that I know him personally. He was a good man. But aside from that, I don't know him.
I know him.
We never conferred. But on the basis of the decision itself, Justice, did you not happen to evaluate the findings of facts, the conclusion? The conclusion was really, really unjust.
Ma'am,
Napoles was acquitted.
yes. Ma'am, when I was, when at that time, when the, this is the truth, at the time when the decision was penned, I was given a few days to read the decision. They did not talk to me. I read the decision, and I didn't actually read anymore the evidence. Opo. Totoo po yun. They just gave me the decision, and then, tapos na yan eh, sabi nila, pumirma ka na. Teka, babasahin ko. That's what really happened. And then I read it. I found it okay, so I signed it. But it was only a few days, ma'am. A few days before it was released.
You did not evaluate the evidence.
No.
You did not read.
No.
Go over the evidence.
I read only the decision.
You read only the facts and the conclusion. Oh my God. Please, Justice, don't do that again.
Yes po.
It was reflection ito sa iyo, Justice. I was surprised, when I found your name. Why did she sign this? Why did she not dissent? You could have
I was
dissented.
just new there po.
Even the fact that you were new, you should be more careful because you did not know very well the people around you, isn't it? So I think that is a lesson for you. Next time, you don't read only the decision, but the rollo, the records themselves,
that, I've been
especially
reading
the transcript. That decision, gave way for his conviction administratively. And there were clamor among the justices in the in-bank that they said, why should Gregory Ong be the only one charged. Why not include the two other justices? You are just very lucky because majority did not want to go that far there. So that was really a very, very delicate issue. So I think you should be more careful, Justice, before you sign, because you are a collegiate court. Be careful that you go over the entire folio, especially the evidence. And you must also study the personality of the justice you are working with. No, it's not proper that you just know them, you meet them, but knowing them, you join them, for example, for life. You will know their judicial philosophy, their morals, you know. That's it, because you are not alone in making decisions, okay? This is a follow-up question to the question of Justice Lagman. She was correct. Among or between divisions, there has always been flip-flopping. But even in the bank, and I'm sure if you are lucky enough to be appointed, you will observe this. And I'll give you an example. And I will ask you what action or step you will take to avoid this. If this is the case of the League of Cities versus Comelec et al. There were 13 municipalities who aspired to become cities. And therefore, 13 laws or 16 laws were passed by Congress, converting these 16 municipalities into cities. Because of this, the League of Cities filed petition against them. The contention of the League is that, you know, their income will be less, and because there will be more cities. In the first decision, the Supreme Court, the plaintiff was Justice Antonio Carpio. The ruling was the 16 laws are declared unconstitutional, and that therefore the League of Cities won. Okay. Later, because upon motion for reconsideration, the dissenting opinion won, so this case was assigned to Justice Velasco. Justice Velasco, this is the story of the flip-flopping decision in the in-bank. When Justice Velasco decided the case, he decided in favor of the 16 municipalities, declaring that the laws are constitutional. So there is flip-flopping. According to Justice Carpio, unconstitutional. According to Justice Velasco, unconstitutional. And suddenly, constitutional. The case again was decided this time by Justice Bersamin. So there were three ponentes, my goodness.
Ma'am, what is the decision of Justice Bersamin?
The decision of Justice Bersamin was, well, the discussion was different. According to him, why should not the court give autonomy to the 16 municipalities, something like that. And so his decision was the 16 laws, they call it cityhood laws, are declared constitutional. So clearly, there has been flip-flopping. Do you see now how flip-flopping works? And that is the difficulty. Even if you are already a member of the bar, I don't know how you will remedy this situation. It's not only League of Cities. There are other cases like the PAL, the Nagat, other cases, not only 5, more in the bank. So I'm just clarifying to you the meaning of flip-flopping.
Yes, ma'am.
Of course, you know that the Supreme Court declared unconstitutional the DAP and the PDAP. Okay? Basically because of violation of separation of powers. Do you think President Aquino, before he steps down, can be impeached
On the basis of?
of these decisions, finding the DAP and the PDAP unconstitutional?
The DAP and PDAP,
First, answer me, what are the grounds for impeachment?
grounds for impeachment.
Under the Constitution. Culpable violation of the
Culpable-
Constitution.
culpable
What else?
violation.
Treason.
Treason.
Graft and corruption. High crimes. Betrayal of public trust.
Oh, ma'am, what is the
What do
question
you
now?
think? Bribery.
Oh, your question is, should President Aquino?
Can President Aquino during his term be impeached on the basis of the findings of the Supreme Court that the DAP and PDAP are unconstitutional?
Ma'am, the DAP
We are testing how you will decide issues
Ma'am,
when
the
you
DAP
become member of the Supreme Court.
The DAP and the PDAP are products of the legislature, correct?
Declared unconstitutional.
Opo, but they are products of the
No, the DAP is not. Only PDAP.
PDAP. Okay. So should the president be impeached
Yes.
on the basis of the declaration that the DAP and PDAP are unconstitutional? Treason, betrayal of trust. Betrayal of trust. Should the president...
Was there culpable violation of the Constitution on his part? Yes or no?
I don't think so.
Okay.
Because he is there to implement the executive.
In the DAP, he was both the legislator and the implementer, remember?
Yes. Should he be impeached?
Anyway, when you reach home, think about it. I will not give you the answer. This is also a follow-up question to the questions of Attorney. Yes, let's discuss about these measures adopted by the Supreme Court. A while ago, you were discussing judicial affidavit. In the judicial affidavit doctrine, the Supreme Court has already stated there the cases wherein judicial affidavit or doctrine will apply. Okay, but do you believe in the wisdom or effectivity of judicial affidavit? Do you believe that it really expedites disposition of cases in the trial courts? First question, who prepares the affidavits?
The lawyers.
The lawyers. Okay. On the basis of the judicial affidavits, there are no more direct examination, direct testimony.
Opo.
Okay. As a trial judge, and you said you were there for so many years, when you discern the demeanor of the witness, simply by simply adopting his or her judicial affidavit. Because the lawyer will say, this is direct testimony of my witness.
Opo.
Can you discern the demeanor? No. So that is one of the disadvantages. Number two, who prepares the affidavit? Not the witnesses, but the lawyers. Number three, all right.
Based on the facts given by the witness.
Yes, but it's the lawyers to prepare. O di siyempre, magagamot-gamot na ng lawyers yun. Diba?
Opo.
All right. Assuming that there has been expeditious trial, but all these cases will pile on the trial judge table. Mabilis. Do you think the judge will be able to decide these cases within 90 days? No. Do you think the prosecutors there in the DOJ will be able to submit all affidavits, judicial affidavits required? No. That's why they have been complaining against the adoption of this judicial affidavit doctrine. With respect to his question concerning the proposal of Justice Abad, you know, he wants the trial to appear like a board meeting. The judge will be at the end of the table. The lawyers will be there near him, and all the witnesses there. That will be the scenario. Do you like that kind of hearing trial to
Magulo po.
happen? And so we told him, Justice, how will the litigants lawyers will respect the poor judge? He will lose his dignity. Imagine just sitting there at the end of the table, conducting trial. And, you know, the procedure is the judge will ask the witness as if, you know, narration of facts, and then he will ask the other witness there, oh, what is your comment? What's your defense? Do you like that kind of trial to happen?
No, ma'am.
Of course not. Oh, sorry. It says I must stop. Thank you and good luck.
Thank you po.
Apolinario Dre Bruselas Jr. Justice.
Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
Okay, we will now start the interview. May I request Attorney Cayosa to start?
Thank you, Justice Gutierrez. Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
We have extensively interviewed you twice for the position of Supreme Court Associate Justice in 2011 and 2014, and for the position of Sandigan Bayan Presiding Justice in 2013. And as you know, the JBC conducts a survey as to the reputation and abilities of our candidates. So I take this as an opportunity to inform you of the reactions with regard to your application, both positive and negative. So let's start with the positive. It states here that you are principled, uncompromising, upright, and dispenses justice without fear or favor. You are an innovator and was instrumental in the design and successful implementation of what is the current case management information system of the Court of Appeals. That's on the positive. Now, we take this also as an opportunity for you to respond to the negative reports or allegations made against you. As in 2011, there was an opposition filed by Attorney Eligio P. Malyari against your application, raising the same grounds.
Yes,
Would
Your
you care to respond to this? I believe you have been given a copy of his
Yes, Your Honor.
opposition, and you have also submitted a letter to Attorney T. Capacite. But for the record, would you want to
Yes,
respond to it?
Your Honor. Very briefly, this opposition, Your Honor, is sourced from or originated from a complaint filed by Attorney Malyari concerning a case where he was a party. And this case is a case where he lost in the case of the Court of Appeals, a certiorari proceeding. And this was a case which was decided by Division of 5, where the voting was 4:1. And then there was a complaint filed against me as a result, because I happened to be the ponente. I wrote the decision for the court, signed by 4 members of the Division of 5. And later on, there was a complaint and there was a motion for inhibition. I inhibited, together with the others who signed with me, and another Division of 5 was constituted. And it turned out that that Division of 5, with new members now, except for the the remaining member who dissented and who did not want to inhibit, again turned out with a 4-1 decision. Actually, this case, Your Honor, should have been brought up by Rule 45, but I do not know, it was not brought up by the party concerned. Instead, the party wanted the Court of Appeals to look at it again, this time by the regular first division, which is unprocedural. But in any event, Your Honor, this case, the source of the opposition has been dismissed by the Supreme Court in 2011. And despite the attempts to keep the matter alive, these motions have all been successively resolved in the negative by the Supreme Court, Your Honor. I submitted a written report, a written response with the attachment of the Supreme Court resolution, and I did not anymore attach the other numerous resolutions, all denying the revival or whatever of the movement's desire. So the opposition really, Your Honor, is based on a case coming from a sole litigant. That is the long and short of it, Your Honor.
I believe that this was the same issue raised in 2011.
Yes, Your Honor, the very same issue. And until now, still being raised against me. I cannot help it that some people, one, would take it so sorely against me. It's just unfortunate, Your Honor, but the records will bear out that there is nothing there other than being professional about the matter.
There's another report on an allegation that the ATM card of your staff is being quote-unquote captured.
That's not true, Your Honor. We have an ATM cards. I have 4 lawyers and 4 non-lawyers, my utility and my driver. All of them have their own ATM cards. I have an executive assistant. My son is a coterminous one. We share the same card. When they open the accounts, my son and my driver and my utility, they all open at the same time, and we all have what you call a joint accounts. They are not captured at all, Your Honor.
Sorry, who has joint accounts?
Me, my son, my driver, and my utility aide. When we opened the accounts at Land Bank, way before the ATM was operationalized, we opened accounts already.
Oh, I thought that is this for payroll?
Now it's now for payroll because now we are using the ATM for paying our staff. But all of our payments go to the ATM accounts, and my staff are paid, except for the 3 others that I mentioned, my son, my driver, and my utility aide. All of the payments are drawn by them directly. The 3 others, they can draw their pay from the ATM. They have their own ATM cards also.
So now, does your driver have his own ATM card?
They have their own ATM card.
So, but at one point, it was a joint account. You're saying?
Until now, it's joint, Your Honor, because what happens is, it's joint. We never close the account. It's still joint. They have access to the account. If the allegation is they are not paid, then that is something that's very, very deniable. They are paid. In fact, I pay more my utility aid because I'm using also as a driver. I give him more. So if that is the purpose of the allegation that staff members are not being paid, that is very, very untrue, Your Honor.
But wouldn't it be more prudent to just have separate accounts?
That should be correct, Your Honor. But as I said, when we started before the ATM payrolls, we already have joint accounts with the 3 of my staff. Only the 3, these are personal staff. But if your suggestion is that they should now be separate, that's well and good, Your Honor. We should now separate. We have not had the time to have a separate account for only the 3.
Thank you, Justice.
Yes.
Now, with respect to the CMIS,
Yes, Your Honor.
I understand that the other offices of the Court of Appeals already have the raffle of cases
Yes, Your Honor.
electronically.
That's
Have you been
correct.
able to adopt the same procedure here in Manila, in the Manila station?
Well, actually, Your Honor, I have been also pushing our PJ to adapt this in Manila because in Rian de Oro and Cebu Station, we already have electronic raffle since 2 years back. We have the same program, the same mechanism for doing that, but I think our PJ wants another feature added for the CA station. That's probably why he until now, he is of the view that we should not yet employ the electronic raffle in Manila. But if you ask me, Your Honor, it can be operationalized even now or even tomorrow because the same program is available.
So is that part of the CMIS system? I mean, like the ability to conduct an electronic raffle, is it a feature that you could actually add as part of the system?
It is a feature that's already in existence. It is existing in Rian de Oro and Cebu Station, except that in Manila, we have not adopted the electronic assisted raffle. We are still doing the manual raffle because our PJ wants an additional feature incorporated into that electronic raffle program. And this is under USAID assistance, and as of now, USAID is concentrating on the e-courts project. This feature which our PGA wants to be added will be considered this year, Your Honor. But that is beyond my duty, beyond my responsibility to be able to enforce that. Right now, we have in the Manila station of CA electronic raffle. It's a PJ's call, Your Honor.
Justice,
Yes, Your Honor.
you are very active, no, especially when it comes to training of judges.
Yes, Your Honor.
And I suppose you also very you closely coordinate with the members of the academe. What would you recommend if you become a member of the Supreme Court to improve the system by which we train our future lawyers? What would you want to highlight in order to make them more competent and more upright?
Well, insofar as having better judges is concerned, Your Honor, I think we have in place already the program which we call the pre-judicature program. I think that's a good program, except that it has to be improved further. Right now, I think it is not implemented in a way that all who would want to be judges get the training that should be given them. So that's one point, Your Honor. We have to improve the pre-judicature program. Then later on, when they are appointed as judges, we have to have what we have is an orientation program, which lasts for about 5 days to 10 days at the most. And I noticed that in these orientation programs, what the subjects that are taken up are mostly a review of substantive law. My position is that we should spend more time of the 10 days that are allocated, at least half, if not more than half of that, should be devoted to trial management, handling of evidence by judges, and actually, Your Honor, because it should be devoted to better trial management. How to craft that, what kind of program to put in place will have to be thought out by training staff. But to me, because it's important to have good judges at the trial courts, with good judges, we will have less appeals going up the appellate courts, because the litigants would be generally satisfied with the decisions. If you do not have good judges at the lower courts, we will have more appeals going up. So those are 2 points, Your Honor. Post-appointment and pre-appointment and post-appointment. We have to look at the training programs that are being right now dished out to our judges and prospective judges.
That was my final question, Justice Bruselas. Thank you, and I wish you well.
Thank you also.
Thank you, Justice Gutierrez.
Thank you so much, Attorney Cayosa. And now may I request Attorney Mejia to continue.
Thank you, Madam Chairman. Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
We have interviewed you no less than 3 times, at least during my stint here. And the few questions that I have for you have been addressed earlier by Attorney Cayoso, so I will no longer have any question and defer to Attorney Guevara. Good luck, Justice Bruselas.
Thank you very much, Your Honor.
Thank you. Thank you very much, Attorney Mejia. May I request Attorney Guevara now?
Thank you, Madam Chairman. Good afternoon, Justice.
Good afternoon, Your Honor.
Justice, I'm quite bothered by the reputation that the Court of Appeals has recently gained. The reputation that TROs are for sale at the Court of Appeals. Do you have any personal information as to the truthfulness of these reports?
With respect to having a personal information, Your Honor, I must say that I do not have any personal information. In the sense that I have not been able to deal with such an factual situation.
But you're
there are
aware-
indeed
yes.
reports. There are indeed reports
Yes.
that PROs are for sale, and we in the Court of Appeals are also very saddened by this. What I can say, Your Honor, is it is our duty, if ever, as a member of the court, if ever we encounter such a situation, it's our duty to report that, and not only to report. Under the law, we're supposed to initiate the proper complaint about it. It's just unfortunate, Your Honor, that truthfully and personally, I have not encountered such. Nobody has come up to me to say that, for this matter, we would like to have a TRO. In my own case, Your Honor, you can see the records. I have not issued a TRO. In the last 10 years, I only have issued about 3 TROs, Your Honor, and these are all TROs which eventually led to a decision in favor of the applicant.
Has the leadership of the Court of Appeals done anything about the matter so that the said unpleasant reputation of the Court of Appeals is removed?
As a member of the court, Your Honor, I can say that we have an ethics committee which is supposed to look after, to address these things. It is actually the PJ's job as the leader of the court to be able to hammer out and pursue a more robust response to these allegations. I remember that we have, the last one that we have is that thrown out by Senator Trillanes, and that matter was referred to the Ethics Committee. I have yet to find out what the status is of that. I do not know, but that's the last one I heard, Your Honor. Of course, there are other reports about cases concerning TROs, but as I said, Your Honor, personal knowledge I do not have. It's really bothersome for someone, the Court of Appeals, for us, to be always met by that TROs are for sale. But we are strictly monitoring. The Court of Appeals, every month, there is a report that's submitted to the Supreme Court detailing the number of TROs that have been issued in such and such cases. And these are records. We can go back to that. Should there be a complaint that would arise, then these records will be able to help out in an honest-to-goodness investigation.
Okay, let me talk about the Supreme Court now, Justice.
Yes, Your Honor.
Where you are applying for a possible position due to the vacancy. Are you aware of the existence of any personal alliances among justices of the Supreme Court in terms of the manner of their voting on crucial cases before that?
Personal alliances. I'm not aware of any personal alliances, Your Honor. All I can say is that I know, because I know a number of the justices of the Supreme Court, because some of them were my colleagues in the trial court. So if you're talking about in that respect, whether or not this and that justice is allied to this, what I can say is that probably because of previous positions, they may have the same thinking with respect to what this or that matter. But as to whether they are personally allied, I am not aware of personal alliances, Your Honor. I can say prior positions, prior agrupations.
Do you think political considerations come into play in rendering judgments in the Supreme Court?
My answer to that, Your Honor, is a very frank statement that the Supreme Court, contrary to what many may believe, the Supreme Court is actually also a political organ of government. While standard theory says that the judiciary is apolitical, the Supreme Court, at least, because it's at the apex of the judiciary, the Supreme Court is not really apolitical. It's a political organ of government. In other words, it also processes things that are political. So my answer is the Supreme Court is a political organ, and therefore political processes come into play. But of course, the decision always that is the decision that comes out is always the one that is rendered with the Constitution as the standard. So all process may come in, but the Constitution is the duty of the Supreme Court to ensure that all things that are undertaken meet the test of the Constitution. That's the final standard, Your Honor. It's the Supreme Court's duty.
All right, then, if you were in the Supreme Court, let's say you're lucky and fortunate enough to be appointed to the Supreme Court, and let's say the matter of, or the issue of Grace Poe's being a natural-born citizen is still in question, how would you vote on that matter?
To be very frank with you, Your Honor, at this point, I have only seen what have been published in the papers. It will be imprudent from a sitting member of the court, whether it be a lower court judge or appellate court, to publicly air his opinion on something that he has not studied very well. So if you are asking, Your Honor, how will I vote?
Your opinion, not necessarily on how you're going to vote, but on your opinion on whether or not, based on the exhaustive discussion that has been published in newspapers and media about the pros and cons,
Yes.
what opinion have you formed regarding the issue of whether or not?
That is where the danger, Your Honor, of forming an opinion right now will come into play. Why? Because media right now is utilized by all parties concerned to advance their own opinion, advance their own positions. So for us to rely on the base of newspapers will be very, very imprudent. I have had my experience in these matters, Your Honor, and in my 8 years as a trial prosecutor, 8 years as a trial judge, I have seen that many things that appear in media, when brought to the court, vary very greatly. What is, for instance, presented as 10 kilos of shabu confiscated, when it's brought to trial court, it becomes 8 kilos. I mean, there are variations. That's why it's very difficult, Your Honor, to form an opinion on the basis of what one reads in the papers. This is not to say that the papers are not truthful, not at all. What I'm saying is, especially in a very political issue, whatever is brought out in the papers necessarily must be viewed as, with a second sense. With due respect, Your Honor, as much as I would like to make an opinion, I cannot do so because it will be imprudent. I do not have the facts before me to make such an intelligent opinion.
I respect your answer, Justice.
Thank you very much,
Thank you
Your
very
Honor.
much.
Thank you so much, Attorney Guevara. I now may request Justice Lagman to continue.
Okay, actually, I don't intend to question Justice Bruselas anymore because we have interviewed him quite extensively since 2011.
Thank you very much, Your Honor.
And last time, he was nominated for the Supreme Court. Okay, I just want to be clarified of your statement to the question of Attorney Cayosa regarding your joint account with the
Yes.
members of your staff.
Yeah. No, just
want
the
to be
three.
clarified.
Only with 3, Your Honors. Only with 3 members of my staff. My co-terminus executive assistant, my son, my driver, and my utility. These accounts were opened way before we started the ATM payroll. This was opened about 6-7 years ago. The only reason why we have not been able, the suggestion is well taken, that perhaps we should now disjoint the accounts. But we have not done that because there was no reason for it. It was very convenient. And as a matter of fact,
People might
that's why,
another
given that,
meaning to that.
precisely, I think that observation was precisely based on that. That's why, Your Honor, I'll take the suggestion that tomorrow I'll have these 3 joint accounts disjointed and tell them to open their own accounts.
Buti na para
That's
to
right.
avoid
Yes, Your Honor.
suspicion or from anybody.
Yes,
Diba?
Yes, Your Honor. That's correct, Your Honor. But I thought that if the complaint were they were not being given their salary, then that's another matter because definitely I do not do that. Your Honor. They would have come out and we have had cases like that in the court where employees have charged their superiors for withholding their salary. That's even an offense under the criminal code, Your Honor.
Oo nga. Pero mabuti na. It's better na...
Yes, the only reason, as I said, to emphasize, Your Honor, that it was opened up way ahead. And we patagal na po yun eh. Hindi natin naakalain na it will become a problem. But now that it has been raised, it is really
avoid any
prudent.
misconception.
That's right, Your Honor.
Okay, on that note, I have no question as I've stated, and I wish you luck.
Thank you very much, Your Honor. Thank you very much, Your Honor.
Okay.
Thank you so much, Justice Lagman. Justice Bruselas, you know, every complaint, every opposition reaching the JBC, we read. Every word we read. I have been reading the complaint of Attorney Malyari. The case that reached your court, the Court of Appeals, would you not consider it a sort of flip-flopping? Because in the beginning, it was P.J. Reyes who penned the decision
Yes, Your Honor.
in favor of Malyari, stating that the consignation with the trial court below is valid. That was the decision of P.J. Reyes. I read it.
The certiorari was denied, Your Honor.
Yes, but yes, you mentioned certiorari.
Yes, certiorari.
There was a decision of the RTC,
Yes, Judge Marigomen and
Judge
Patillo.
Maligomen. It became final and executory.
That's
But the PNB raised the issue to your court via petition for certiorari under Rule 65,
65, Your Honor.
which I believe is very improper because a certiorari cannot be a substitute for a
For
lapse
lost appeal.
appeal.
That's correct, Your
Okay. On that point alone, as if there was already a flaw in the procedure. At any rate, P.J. Reyes decided the case.
Yes, Your
There
Honor.
was no grave abuse of discretion, and he upheld
Yes, Your
the
Honor.
consignation
Yes, Your
down below. But there was a motion for reconsideration,
That's
so
correct.
there was a division of 5.
Yes, Your Honor.
You were the ponente,
Yes, Your Honor.
and you reversed the decision of P.J.
The
Reyes.
position that I took, where the 3 others concurred in, was that certiorari is available. It is correct that certiorari cannot be a remedy for a lost appeal, but precisely, Your Honor, the point of the certiorari was, the movement was saying that appeal period had not yet prescribed. In fact, I remember the Lightest rule, where a first period of 15 days is given. What happened below was that the trial court merely treated as a pro forma matter the appeal and dismissed the appeal perfunctorily. That was the point that was raised by the movement. And to us,
Because the decision has become final and executory. At any rate,
Which is
let us not
contested.
discuss the merit anymore.
Yes.
Is that not an example of flip-flopping in the same division?
it is not a flip-flopping, Your Honor, because it was only flipped once.
Flip once.
If you
Okay.
if you say flip-flopping, it goes from one side to the other. But precisely, it was consistently decided against and allowed certiorari. Why was this necessary? Because the court wanted the matter to be elevated on a full-blown appeal. Because what the movement was what the other party was saying is that the case should be killed at the below already. But we saw that the trial court, because the point was there will be no more avenue for the party below to have their appeal carried seen by another court. That was the issue there. And under certiorari, we saw that should be brought up not to the division, to the Court of Appeals.
But it was the fault of the PNB. Why did it not resort to appeal
I think the
within the 15-day period from the finality? Anyway,
I think they had an MR, Your Honor.
I'm just discussing this to you.
Yes, Your Honor.
Just to be
Yes, Your
clarified.
Honor.
Anyway, I
Ju-
just
just to
want
point-
to know.
Just to point out, Your Honor, please, that it is not flip-flopping because it was consistently ruled in the second time that it was a division of 5 again, 4:1 again. I was not there anymore, and the others were there. I just was surprised. They sustained our position. In any event, Your
Anyway,
Honor,
the case is sub judice. It is
yes,
in the Supreme
45. It
Court.
should have been in Rule 45.
Just
very
like the
first time.
case of Grace Po, sub judice.
Yes, Your Honor.
Well, you cannot give your opinion in the case of Grace Po because according to you, you do not know the facts.
Yes.
You will only rely on the newspapers.
That's right, Your Honor.
But Justice, the facts are very clear. All right, define under the Constitution who are natural-born Filipino citizens.
You are talking
That
about
provision alone, you will not answer.
You are talking about the case of Grace Po, Your Honor.
Yes.
Well, under Article 4 of the Constitution, there's the definition of who are the citizens of the Philippines.
No, there is a
Natural born.
specific provision defining who
Yes.
are
Natural-born
natural-born
citizens.
Filipino citizens.
That's
You
correct.
are referring to that provision who are Filipino citizens. There is a specific provision defining who are Filipino citizens.
Yes, the provision.
Because, you know, one of the rules of the JBC in determining the qualifications of applicants for judgeship or promotion, is to test also their mastery of laws, rules, jurisprudence. So my question is, who are
Natural-born citizens.
natural-born Filipino citizens as provided for by the Constitution?
Article 4, Section 4 says that natural-born citizens are those citizens who are citizens from birth without having to perfect or do anything to acquire or perfect their citizenship. These are deemed natural-born. Now, who else are natural-born? Those who elect, those who are born of mothers, those born...
No, I'm not asking that question, only the natural-born. All right, does Grace fall under this definition?
Well,
What do you think?
I wanted to point out, Your Honor, that this other provision, who else are natural...
No, the issue is natural-born, hindi yung Filipino. Who are natural-born Filipino citizens? Because to aspire for the position of president, to aspire as senator, the aspirant must be a natural-born Filipino citizen.
That is correct.
Hindi lang Filipino citizen. That's why, under your definition, is Grace Poe a natural-born Filipino citizen?
Minus all the other facts, minus assuming that there are no other facts, it's clear that she is not a natural-born. But, Your Honor, remember, there is now this ongoing DNA testing, so-called parents, factual in nature, which we are not aware, the court is not aware of. So hypothetically...
Si Foundling, she has admitted that.
But I was going to point out, Your Honor, the next provision, which says, children born before January 17, 1970.
No. Na hindi na yan natural-born.
No, you know,
They are only Filipino citizens. Read the Constitution, I will show you. At any rate, let's put a stop to that. Sub judice yun, magagalit ang Supreme Court.
Your Honor, this is not hypothetical only, Your Honor, because I have the Constitution which says, Your Honor.
Hindi yan natural-born. The definition is, the following are Filipino citizens.
That is correct, Your Honor, and there is a provision, sir.
Kung Filipino citizens lang hindi natural-born,
Yes,
she is not qualified.
Your Honor, natural-born, this is another natural-born citizen. I hope, with due respect, Your Honor, I hope you will permit me just a minute, just 1 minute, Your Honor, which says, that same provision has this, it says, that next sentence, Your Honor, it says, those who elect Philippine citizenship in accordance with paragraph 3, section 1 hereof, shall be deemed natural-born citizen. So this is look, this is the same paragraph continuation of the sentence of section 2. Section 2 says, natural-born citizens are those who are citizens of the Philippines from birth without having to do anything to acquire or perfect their Philippine citizenship. Next sentence, those who elect Philippine citizenship in accordance with paragraph 3, section 1 above, shall be deemed natural-born. And who are these? Above is those born before January 17, 1973, of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. That's the other provision, Your Honor, that I was
Who
referring
is
to.
her mother?
That's why it's, Your Honor, it's a factual matter. That's why I wanted to say, we are not yet able to answer that question.
And she resorted to DNA, so she performed something
That's why I said,
very
Your Honor,
clear.
that's why I said, Your Honor.
Anyway,
You cannot have
it's in the Supreme Court.
That's right, Your Honor.
I don't know what will be the decision. Anyway, that's my
Subject to
opinion.
factual...
So let us see how you develop or you will develop your concurring or dissent. If you were already a member of the Supreme Court at the time it decided the case of Chief Justice Corona, declaring that his appointment was constitutional. The ponente was Justice Bersamin. Will you concur or dissent? Reason.
Well, this is already a decided case, Your Honor, and to my recollection, the
Remember the cases of Villarta, Villanueva,
the two judges.
members of the judiciary.
Yes, the two judges.
And the appointment was really issued within the prohibited period.
It was the court departed from that. These two judges who were appointed.
No. The appointment of Chief Justice Corona was issued within the prohibited period.
That's why
Within 2 months prior to the election and up to the end of the term of GMA. So will you concur dissent?
the decision of, in the case of Judge Corona, reversed the decisions of the two judges who were also
No.
appointed.
My question is, concurring ka ba or dissenting?
I go with the earlier decision of the two judges that were appointed, but they were not allowed to sit because their appointments came within the prohibited period. That is my respectful position, Your Honor. And I with due respect to Justice Bersamin, I think
I agree with you. Next case. How about the case of Mayor Erap?
the
The
case of,
pardon,
well,
valid or not valid, legal or illegal?
I'm trying
Will you
to
concur or dissent?
I'm trying to recollect the facts. The way because the nuance there, Your Honor, is that the way the executive order was crafted, it was crafted in such a way, in a very, 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 not deceitful, no, but in a very crafty way, that it would be susceptible of any decision. If we
There was a portion there that he is prohibited from exercising,
And at the same-
from holding any other government position.
but
But at the same time,
yeah.
he will enjoy his civil
civil
and
liberties.
political rights.
Yes, Your Honor. That's why it was craftily. If this last portion was not there, I would say that it should have been against. But because of this second part, I think the decision there
So you're concurring.
had enough basis, Your Honor. That is my respectful
You are
position.
concurring,
Had enough basis because of that, the way the order was crafted.
despite his personality,
It's not about the personality, Your Honor. It's about what has been written on.
despite his moral conduct.
The elections, Your Honor, will be the one to determine whether one is
Okay, last
qualified.
question. The U.S. Supreme Court decided only 100 or less than 100
90
cases
cases.
a year.
Yes, Your Honor.
That's a fact, every year. We had discussion about this matter when we visited the Supreme Court of America. And
Yes, Your Honor.
we asked the justices, how do you do it? Okay, despite the fact of the number of appeal cases coming from the 50 states,
Yes, Your Honor.
yet
They are able to maintain.
imagine for 1 year, less than 100. And they told me sometimes only 87 or 85.
About
Do you
90.
think time will come when our Supreme Court, and considering that this is a very, very small country, will be able to attain that kind of achievement? Or it will only remain a dream?
But I think the reforms that are in place, Your Honor, will eventually lead to that. The reforms that are being undertaken. Well, right now we are trying to automate all courts. When you automate the courts, you'll be able to at once see the aging of cases. Because now, the cases are placed in index cards and papers, they are easily lost. But if you have automated procedures, all those concerned, all case processors will see how the cases are aging. And naturally, you have to target first aging cases. Now, about the Supreme Court of the U.S., why is it that they were able to do it? I was told in our visit there that they really concentrate on certiorari petitions. And I think the way they do it is that amongst them, the 9 of them, they give out a list of what should be allowed and what should not be allowed. If it's in the list of the 9 of them, then it gets into the court. If it's not, then it's not even considered. So there is a mechanism for processing the thousands and thousands of cases that are brought up to the court. And I just wanted to point out, Your Honor, that the Supreme Court actually, if you look at the powers of the Supreme Court, all of the appeals that go to the Supreme Court are discretionary. They do not have actually, they cannot be forced to act on the case because many of their jurisdictions are concurrent with the Court of Appeals, with the RTCs. For instance, certiorari, prohibition, mandamus, quorum, these jurisdictions are originally in the Supreme Court but also concurrent with the other courts. So there, I think the way to do it is to really ensure that certiorari petitions are reduced to a minimum. And how to do that? There are various ways. The U.S., they come up, they list.
In fact, Justice, we asked them, how do you do it? And then they said, this was the explanation.
Certiorari list.
Of course, we appoint the best lawyers in the country as the clerks. And then there is a group of lawyers who handle all these cases, who study these cases very well. And so that only few will be elevated to the bank. Oh, they have no division. At any rate, when I recommended this to Chief Justice Puno, he declined. It is not applicable in the Philippines because he doubts the integrity of lawyers. I don't know why.
That is something, one thing.
Last question, Justice. What cases from the Court of Appeals do you think should no longer be elevated to the Supreme Court?
If, Your Honors, please, I think most of the cases should stop at the Court of Appeals. And except, I'm talking only, Your Honor, we now have in People versus Mateo, the Supreme Court brought down to the Court of Appeals actions on cases, criminal cases where the penalty is perpetua. So these ones, as I said, practically all cases, what should go up to the Supreme Court should only be certiorari petitions.
We sent even the cases concerning rapes, labor cases.
Yes, labor cases.
and
Martin.
Yes.
Yes, Martin.
Agrarian. And therefore, like these cases, illegal detainer, simple
Gentlemen,
theft,
yeah, that's why, Your
or-
Honor, even into possessions, I think this matter should no longer reach the Supreme Court.
That's why justices like you should submit to the Supreme Court this kind of recommendation to expedite
Yes, Your Honor, I will at once
position.
convey this to our
Okay, thank you
PJ.
very much, Justice. Good
Yes,
luck.
Your Honor. Thank you very much, Your Honor.
We can conduct a separate investigation, Attorney Mayari, but not here.
Thank you very much, Your Honors, for the opportunity to appear before the Honorable Judicial Member Council. Thank you very much. Maraming salamat po.
Good afternoon, Attorney Mosquera, Deputy Ombudsman. Please sit down. And so may I request Attorney Cayosa to start the interview.
Thank you, Madam Chairman. Good afternoon, Deputy Ombudsman Mosquera.
Good afternoon, ma'am.
We interviewed you extensively when you applied for the position of Deputy Ombudsman.
Yes, ma'am.
In fact, you were shortlisted twice. And I recall distinctly that you had this passion to pursue graft and corruption.
Yes, ma'am.
And that is the reason why you applied for your current position.
Yes, ma'am.
You assumed on June 1st, 2012, and you would have until 2019.
Yes, ma'am.
Why have you decided to aspire for the Supreme Court? Not even midway or at least a little over midway your term as a Deputy Ombudsman.
Yes, ma'am. I have a career in the private sector, ma'am. And when I decided to join the public service, my only motivation was really to serve. And the question was also, I also considered the question. But in the Office of the Ombudsman, our main goal is really to address the problem of corruption. And I believe that I am ready to serve in another capacity, in a much broader capacity, pursuing the same principles of transparency, accountability, integrity, and the promotion of the rule of law. When I left the private sector in 2011, as the Honorable Attorney Cayosa mentioned, I asked myself what would be the proper timing to serve in government. Actually,
definitely in the latter years of my life after I have exhausted all possibilities in the private sector, or earlier, where I can offer the best years of my life to government service. I chose the latter, Your Honor, because I believe that when you aspire to serve the people, to serve the public, it should be to offer the best years of your life. And I believe that at present, I would consider myself to be in that stage. I am healthy. I fairly have the skills and the basic knowledge to serve in a different capacity, and I want to offer that in another area, in another field, particularly in the Supreme Court, rather than at a much later time. The second reason also, Your Honor, is opportunity. This will be the last appointment that the present president will make, and I believe that it is a good time to offer myself. The current president has created, the present administration has created an atmosphere or an environment where anyone can aspire for office as long as you have the integrity, the competence, and the commitment to serve in public office. So those two are my reasons. First one is I believe I want to offer the best years of my life to public service, including service in the Supreme Court. And secondly, there is a golden opportunity now to serve in the Supreme Court.
Thank you, Deputy Ombudsman. Now, let's go back, focus on the work that you currently do at the Office of the Ombudsman.
Yes, ma'am.
I recall that when we interviewed you, there was a problem as to the actual state of the caseload
Yes, ma'am.
pending before the
Yes, ma'am.
office, specifically for the Office of the Deputy Ombudsman for Luzon.
Yes, ma'am.
And we even gathered information that records of the cases were hidden in the ceiling, in different places within the office, which made it difficult for you to determine what your actual caseload was really about. May we just know what steps have you taken to address this problem as regards the actual caseload, and what have you done, to address this problem?
In fact, the centerpiece program of the current administration, the Office of the Ombudsman, is the Zero Backlog Program, which is to address the problem of a backlog. In fighting docket decongestion or fighting backlogs, Your Honor, there are three things that are important. Number one, you must have to reduce the intake to some extent. Number two, you have to attack aggressively the backlog. In other words, have a conscious, determined, and organized effort to really attack the backlog. And I use the word attack deliberately because it has to be like an aggressive attack. And thirdly, to ensure that the current cases do not add to the backlog. This, Your Honor, we were able to do in the Office of the Ombudsman. We were able to reduce the intake. Number two, we were able to attack successfully the backlog. And number three, we were able to ensure that the current cases, Your Honors, filed within the year do not add to the backlog but are actually reduced. Right now, Your Honor, when I assumed office in the Office of the Deputy Ombudsman for Luzon in 2012, the caseload of the office was standing at around between 7,500 to 8,000 cases. That would be about 50% of the total workload of the Office of the Ombudsman, handled by the Office of the Deputy Ombudsman for Luzon. So we're looking at around 15 to 16,000 total workload for the entire office. Through these efforts, the Zero Backlog Program, aggressively attacking the backlog, reducing the intake, and ensuring that the current cases do not add to the backlog. The latest figures that I have from our computer system, Your Honors, I'm happy to share with the Honorable Council that currently we now have the Office of the Deputy Ombudsman for Luzon only has a workload for 2015 of 3,000 cases. So from 7,500 to 8,000, it is now brought down to 3,067 cases, Your Honor. Our intake last year, 2015, was only 539 cases. And currently, Your Honor, our clearance rate, that would be the cases received for the year, cases resolved for the year over cases accepted or received in the docket is way above 100%. That means that we're still going after our backlog successfully. This situation now, Your Honor, in 2016 will allow us to inject more quality into our decisions and will ensure that cases filed in court are successfully prosecuted to its conclusion. And it will augur well for the enhanced credibility of the Office of the Ombudsman. And definitely, Your Honors, create deterrence against corruption, which is really the mandate of the Office of the Ombudsman. So that I'm happy to share with the Honorable Council.
Thank you, Deputy Ombudsman. Some sectors, particularly some of the practitioners, have actually raised the concern that there are still cases, old cases, some of which are already close to reaching the period of prescription. How are you addressing it so that to ensure that these cases will not reach the period of prescription where it will be no longer feasible to prosecute against errant public servants?
In any zero backlog program, Your Honors, it is not advisable to just have or compel our lawyers to resolve cases. You have to have a concerted, determined effort and direct it towards the backlog. And that's exactly what we did in the Office of the Ombudsman, particularly in the Office of the Deputy Ombudsman for Luzon. In relation to that, Your Honors, when I assumed office in 2012 as Deputy Ombudsman for Luzon, Your Honors, the oldest case was 2001. This was 2012. So we have a backlog of 11 years, Your Honor. And this is exactly the situation that Your Honor is indicating. I'm happy to report to Your Honors, ma'am, that as of the last time I checked our zero backlog monitoring records, the earliest case that we have now is 2011. So we now have a backlog of only 11, 12, 13, 14, and 15. We have brought it down from 11 years to 5 years. In 2 years' time, by the end of the term of the Honorable Ombudsman, we would have brought down our backlog to a period of between 2 to 3 years, Your Honor. That we see happening because the backlog program has already been institutionalized and it is running smoothly, monitored regularly, and the results are really forthcoming. So I can now promise you, Your Honors, that those old cases is going to be a thing of the past. But if I may just add, Your Honors, that there's also the so-called sins of the past, that there have been cases there when the Honorable Ombudsman came in that have been languishing for a long time. That is the cases that we now are having problems with the Sandigan Bayan, because the period of time that it has been there languishing before the current group came in is something that we cannot undo. So we'll just have to exert utmost efforts with the Sandigan Bayan and convince them that the delay is not the doing of the government, that there are extraneous and external factors. And I think the Honorable Attorney Kayos referred to it earlier about people in the past hiding cases, and that would be one of the reasons why all these cases have been there languishing before the current group came in.
Would you consider your work as Deputy Ombudsman done?
Major reforms have been in place under the leadership of the Honorable Ombudsman. The work will never be... corruption is still around, and there will still be corruption in the future. So the work of fighting corruption is never done, Your Honor. But in my personal capacity, in my humble opinion, Your Honor, a lot of the reforms have already been instituted and are actually institutionalized.
Just one point, the warning light has already indicated that my time is up, but I need to bring this to your attention because we received a copy of your motion for early resolution in the regular administrative case filed against you, and I know that you are aware of the existing rule of the JBC that should there be a pending regular administrative case against you, then that would render you disqualified from being considered for nomination. So maybe it would help if this is resolved the earliest in your favor so that we may consider you.
would Your Honor, allow me to comment on the case, or?
Go ahead, please.
Yes, Your Honor. As with all judicial or quasi-judicial officers, there will always be disgruntled party litigants. This case that Your Honor referred to pertained to a letter filed by a 90-year-old lady lawyer regarding a complaint that a letter that he sent to me. The procedure in our office, based on Office Order 183, promulgated by the Honorable Ombudsman, Justice Conchita Carpio Morales, mandates that all these complaints, all these letters are processed through an administrative system. It never gets to me, Your Honor. On average, the Office of the Deputy Ombudsman for Luzon only receives between 70 to 80 letters a day. If you translate it to a week, that would be around 400 a week. If you go on, that would be 1,800 a month and about 20,000 a year. It doesn't get to me, Your Honor, because there's an administrative process that handles it. But that letter has already been acted upon, it's been processed, notice has already been sent to the complainant. But then we cannot stop the party from still filing the complaint. I've already filed as early as October my comment and my answer raising that defense, and I'm hoping and praying that the Honorable Third Division of the Supreme Court will resolve the matter, Your Honor, so that I be given a chance to be considered by the Honorable Council. But thank you for giving me the opportunity to explain it, Your Honor.
As I mentioned, my time is up, and I wish you well. Thank you, and good luck. Thank you,
Thank you so
Justice
much,
Gutierrez.
Attorney Cayosa. Thank you so much. May I now request Attorney Mejia to continue.
Thank you, Madam Chair. Good afternoon, Deputy Ombudsman Mosquera.
Good afternoon, sir. Your Honor.
What has motivated you to pursue an advocacy against graft and corruption?
Your Honors, I really started my advocacy in 1999, about 16 years ago. I was president of our chapter of the Integrated Bar of the Philippines, South Cotabato, and there was one particular really corrupt judge in our locality, and we have been receiving a lot of complaints about this particular judge. So I gathered my board at the time, and despite threats to our practice, we decided to investigate the matter. We found there's sufficient evidence to file a complaint against the RTC judge, and we filed it with the Supreme Court. The Supreme Court acted immediately, within 3 days, in fact, issued the preventive suspension, and the judge was suspended, and then I eventually prosecuted the case before the Honorable Justice Jose Sabio, who was then designated by the Supreme Court to hear the matter. The RTC judge was dismissed from the service for corruption and was deprived of all retirement benefits. He was about to be convicted by the Sandigan Bayan when he passed away, so there was really no conviction. I shared that experience, Your Honor, because that was the starting point of my anti-corruption advocacy. I believe it can really be done. I believe that if parties come together, stakeholders come together, government, well-meaning public officials, the private sector, complainants, witnesses, decide to do something about corruption, even corruption in the judiciary, that something good will come out of it and that deterrence will be created. Since that time, 1999, I have continuously focused my efforts on developing my skills, my knowledge in the area of anti-corruption. This is the advocacy that I'll probably have for life, Your Honor.
You're now eyeing a seat in the Supreme Court. How would your anti-corruption advocacy influence
Yes, Your Honor.
or fit your judicial philosophy in your work as an Associate Justice of the Supreme Court?
The central foundation, Your Honor, of my advocacy is Article 13 of our Constitution, when it stated that public office is a public trust, public officials and employees must be at all times accountable to the people and serve them with utmost responsibility, integrity, loyalty, and efficiency, and then must lead modest lives. I believe, Your Honor, that in my judicial philosophy, this will be a controlling influence, particularly the concept of integrity, the concept of oneness, which is destroyed, ruptured by the concept of corruption. So my advocacy for integrity in the public service, but not only in the public service, but honesty in Philippine society in general, would heavily impact and influence how I would resolve cases if given a chance to sit in the Supreme Court. This is an area where I feel I would be more of an activist judge than in any other area, Your Honor, because I believe that this is something that not only our country needs, but this is something that that even my family can benefit from, and that my children can enjoy a better country and a better place, Your Honor, where they will have more opportunities, Your Honor.
When you were interviewed, in your application then for the Ombudsman,
Yes, Your Honor.
actually, for the Ombudsman position,
Yes, Your Honor.
I remember you presenting a 7-point program,
Yes, Your Honor.
that you would specifically take
Yes, Your Honor.
if and when you are appointed to that position.
Yes, Your Honor.
With respect to your application for the Supreme Court, what are the specific steps will you do regarding the clogged dockets
Yes, Your Honor.
and corruption among judges?
Thank you, Your Honor. These are the two areas where I think I believe I can contribute and give value if given the chance to serve in the Supreme Court. Number one, docket decongestion, and number two, promotion of integrity in the judicial service, Your Honor. If you remember, Your Honor, I submitted a 12-page, 8-point, 7-year plan, and one of the major components of that plan is a 3-pronged strategy against corruption, anchored on 3 things. Number 1, create deterrence. Number 2, prevent corruption. Number 2, educate the public. So in the area of promotion of integrity and prevention of corruption in the judicial service, I will still apply the same strategy. Number 1, create deterrence. That's always the first prong and the first strategy, Your Honor. In other words, that would mean more aggressive enforcement of ethical standards in the judiciary, fast-tracking of cases involving disciplinary cases against judges. And that's also where I started my advocacy, Your Honor, when I had a participation in investigation and prosecution of a trial court judge. And secondly, Your Honor, prevention. There's a lot to be accomplished with the strategy of prevention, particularly in any setting, whether in the executive, the legislative, or the judiciary. In other words, the way to prevent corruption is to increase audits, monitoring, supervision. The introduction of electronic, of automation in the courts would come a long way in terms of prevention of corruption. And then finally, Your Honor, education is still a major strategy in the promotion of ethics in the judiciary. Education not only of the judges, but education of the public, that they should be more demanding of their public officials, particularly of their judges. But more important, they should be vigilant. And even more important, they should muster the courage to really file those complaints and prosecute those cases to its conclusion. And that's the experience that I had in 1999, Your Honor. The only reason why the case against the trial court judge was successful was because there was a complainant and 2 of his children who stood as witnesses, who really pushed the case, who never let go of the case. And that's the reason why Supreme Court eventually had basis to terminate the judge. If I may share, Your Honors, recently I was in the province last week. I was informed that the lawyer who facilitated that bribe was recently disbarred by the Supreme Court. So now it's a case that has been fully closed. Both the lawyer and both the judge and the lawyer has been punished, and that I think will go a long way in creating deterrence against corruption in the judiciary. If I may just go to the second part of your question, Your Honor, regarding docket decongestion, I think our experience in the Office of the Ombudsman with the same issues, the same challenges, would also be applicable to the judiciary. So again, the three-prong formula that I earlier shared with the Honorable Council, reduce your intake, or at least manage the intake. Number two, attack your backlog vigorously. And three, ensure that your current cases do not add to the backlog will be actionable. And this is something that I will advocate for if given the chance to sit in the Supreme Court, Your Honor.
Thank you. That was my final question. Good luck,
Thank you, Your
Deputy
Honor.
Ombudsman Mosquera. Thank you, Madam Chairman.
Thank you again, Attorney Mejia. And may I request Attorney Guevara this time to continue.
Thank you, Madam Chairman. Good afternoon, D.O. Mosquera.
Good afternoon, Your Honor.
This is the first time that I'm sitting in the Judicial and Bar Council, and I'm not sure whether you also submitted an application for the 6 openings at the Sandigan Bayan, resulting from the creation of 2 new divisions. Did you ever submit an application?
I did not, Your Honor.
I am quite surprised that you did not think of submitting an application for any of the 6 openings in the Sandigan Bayan, considering that you are presently with the Ombudsman, Office of the Ombudsman. Is there any reason for that?
I did think about it, Your Honor, but the office that I'm now involved in, the Ombudsman, the Office of the Ombudsman in Luzon, accounts for about approximately around 50% of the cases that are filed with the Sandigan Bayan, and I was a bit concerned about the possible conflict of interest issues that might be raised, and I might make life difficult for my colleagues in the division that I'll be in, where I have to inhibit and then another justice brought in. So I kind of decided that that's not in my career path, Your Honor, please.
I understand. All right. Of course, you know very well that the Philippines is a state party to the UN Convention
Yes, right.
Against Corruption, or UNCAC. And I think we have certain undertakings
Yes,
with respect to our participation in the UNCAC.
Yes, sir.
And I also understand that the Office of the Ombudsman is very much involved in the activities of the UNCAC insofar as the Philippine entity is concerned, the state. All right, so where are we insofar as our compliance with undertakings and in the UNCAC are concerned?
Your Honor, please, if we compare the Philippines with other countries, we're way ahead in terms of compliance. In fact, as Your Honor is very much involved in this, but the record would show, Your Honor, that the Philippines was one of the first that volunteered to be reviewed as far as UNCAC compliance is concerned. A lot of our laws are already compliant with UNCAC provisions. And in fact, right now we are ready for the second review cycle. And in fact, in the last state conference of state parties in St. Petersburg, Russia, the Philippines manifested its willingness, its readiness to be subjected to the second round of review, way ahead of most other countries, Your Honor, please. So our level of implementation is really good, and in fact, we're on a comparative scale as compared to other countries, we're way ahead. But having said that, Your Honor, there are still a lot of things that can be done in terms of legislation, in terms of rules, regulations, in terms of interventions that we can still do. In fact, if I may volunteer, Your Honor, if Your Honor will allow, one law that I think we should have in the Philippines is corporate criminal liability for corruption offenses that corporations actually facilitate, or when corporate officers turn a blind eye to their agents engaging in corruption activities. That is one requirement of UNCAC, that all state parties must must comply with and pass a law on corporate criminal liability. I think that law, if we have it here in the Philippines, would go a long way to ensure that directors and officers of corporations cannot evade criminal liability if they allow, facilitate, and even tolerate their agents engaging in corrupt activities, Your Honor.
Well, it appears to me that the level of our compliance with the Philippine undertakings under the UNCAC
Yes, Your
is rather high under the present
Yes, Your Honor,
administration and under the leadership of the present Ombudsman. So, do you think this can be sustained over a long period of time if there is a change in administration or leadership in the Office of the Ombudsman?
We have covered a lot of ground, Your Honor, and we can no longer and we can no longer backtrack. So I think the momentum will carry us over into the next administration. So in answer to your question, Your Honor, yes, I am confident that this will be sustained.
All right, there's a question here fed from Twitter, and I'd like to ask you. And this is the question. In addition to the condonation doctrine,
Yes, sir.
is there any other bad law, quote unquote, which should be abandoned by the Supreme Court?
Yes, Your Honor. Thank you for that question, Your Honor. There is a Supreme Court decision entitled Marquez. We call it the Marquez ruling. The Supreme Court ruling basically says it interpreted a specific power in the Ombudsman Charter on the issuance of subpoena. The Ombudsman Charter authorizes the Ombudsman or her agents to issue a subpoena against bank records. A Supreme Court ruling was passed, I think, about 10 years ago. A division of the Supreme Court, basically interpreting that provision by limiting it to just that it can only be exercised once a case is filed in court. And that has caused a lot of difficulties for us in the Office of the Ombudsman. Because if a criminal case is already filed in court, then the Ombudsman has no need to issue a subpoena because the prosecution can ask the court for a subpoena. But the more problematic area there, Your Honor, is that before you can file a case in court, you have to have a strong case first, or at least probable cause to file the case. And the way to build a probable cause is for you to be able to access the bank records. So we need that power before the case is filed. But right now, because of that ruling, Your Honors, we cannot directly issue the subpoena to subpoena those bank records because of that ruling. So this is a ruling that has really hobbled the Office of the Ombudsman in the pursuit or investigation of corrupt activities, and in fact it has created an obstacle. So this is one case that I'm very passionate about, and I believe that this case, like the condonation doctrine, should also be abandoned, Your Honor. And it helps that it is a division case, Your Honors.
Thank you, Dio Gerard. A couple of questions more. You come across as a very gentle and kind person, to me at least. But I noticed that you keep 6 firearms.
Yes, Your Honor.
Based on the records in our possession. What is the reason for that? Is that a matter of hobby only, or is this for something else?
First of all, Your Honor, it's a hobby. It's a sport. I engage in the sport of practical shooting. So it's a hobby that I've had for some time. Secondly, Your Honor, I come from Mindanao. And in my younger years, Your Honor, we've had fairly troubled our area in General Santos City has been have seen troubled times, and it has been, my father was a veteran of World War II, and my father have always taught us to use firearms and to defend our home and our family if there is a need to. So I grew up in that environment, Your Honor. But I can assure Your Honor that those arms or those firearms are purely for self-defense purposes, Your Honor.
That explains the M16 rifle.
Yes, Your Honor, but which I have, yes, Your Honor. It's in my record, Your Honor. Yes, Your Honor.
Okay. Just out of curiosity, in the records that I have before me, there is a report of a certain incident that happened at the Ateneo campus,
Yes, Your Honor.
and there was reference to some physical violence involved.
Yes, Your Honor.
Could you tell us what this was
yes,
all about?
Yes, Your Honor, it was an unfortunate incident that I was involved in, and there was a situation, a scuffle erupted. But at the time, I was a new lawyer for just a couple of months. So there was a complaint filed. I defended myself. I filed my answers. I was accused together with about 5 or 6 others, and eventually the cases reached the Supreme Court, both the administrative aspect and the criminal aspect, and in both instances, the Supreme Court dismissed those cases, Your Honor. That incident happened, Your Honor, if I'm not mistaken, in 1993.
Oh.
In 1993, Your Honor. I was just a 2-month-old lawyer at the time, Your Honor, please. I think that was in June. The results came out in May of 1993. So the matter has been closed since about 1996, Your Honor, please, if I'm not mistaken, by way of the Supreme Court rulings in both the administrative and the criminal aspect, Your Honor.
Thank you for the clarification, Dio Mosquera.
Thank you.
I have no further questions.
Thank you, Your Honor.
Thank you so much, Attorney Guevara. And now, may I request Justice Lagman to continue.
Thank you very much, Madam Chair. Ombudsman Mosquera. Good afternoon.
Good afternoon, Madam Justice. If I may, Madam Justice, Deputy Ombudsman only, Your Honor.
But you can Ombudsman. You're practically the Ombudsman for Luzon.
Yes, earlier.
Okay. Now, I was reading your record and I noticed that your litigation experience
Yes, Your Honor.
was limited at the time when you were in 1996 up to 2003 when you were a managing partner of the Mosquera, Dibuco, Alaba, and Ibaso office.
Yes, Your Honor.
And do you think your litigation experience is sufficient enough for you to effectively perform the duties and responsibilities of an Associate Justice of the Supreme Court?
Yes, Your Honor, please. Actually, Your Honor, my litigation experience would come earlier. I started my law practice in 1993 when I joined the law firm of Villarasa and M. Angco in 1990. Actually, in 1992, before I passed the bar. And I continued after I passed the bar, Your Honor. So, and then I went back to General Santos City where I opened my own law practice until around 2001, 2002. And then there were periods where I went back to practice, Your Honor, and then I went overseas to work for an international agency. But then when I returned to the Philippines, Your Honor, and worked for a government agency, Presidential Commission on Good Government, I had the opportunity to head the litigation department of the PCGG. I was the commissioner in charge for litigation, so that was about 1 year and 8 months. And then I transferred to the office of the Ombudsman where I am supervising a prosecution unit, Your Honor, which would also involve a certain level of litigation, Your Honor. So that would be about 3 years to 8 months of experience also, Your Honor. So accumulated total of this, Your Honor, would be more than the years that I stated, Your Honor, because the years that I stated in my PDS, I did not include my ombudsman experience because it was my impression that the question only asked for litigation experience in the private sector or as a trial lawyer, Your Honor. Yes, Your Honor.
Okay. Now, okay, I will still call you Ombudsman Mosquera.
Thank you, Your Honor. Thank you.
How true is the rumor
Yes, Your
that
Honor.
one of the problems in the office of the Ombudsman is lack of good prosecutors?
That is true, Your Honor. That rumor is true.
What are you doing to address this problem?
A lot of things have been done, Your Honor, since the Honorable Ombudsman and this presentation took it to office, Your Honor. We have launched a very aggressive recruitment program, Your Honor, to bring in bright, idealistic, and honest lawyers. However, Your Honor, there are challenges, Your Honor. Number one, the process is quite slow because we have to be very careful because the items that are available are permanent items, Your Honor.
Yes. Okay.
Yes, Your Honor. So we want to be very sure that not only are these lawyers bright, but they are honest. And to vet these lawyers takes some time, Your Honor. The second challenge, Your Honor, is we're also competing with other government agencies.
Like the DOJ.
The Office of the Solicitor General, Your Honor.
Yes.
The Securities and Exchange Commission. The Office of the President. Even the Public Attorney's Office have better compensation packages than the Office of the Ombudsman, Your Honor. Some of the lawyers that you would like to recruit are in the Supreme Court as court attorneys and in the Court of Appeals. So it's a competitive market, Your Honor, and we have very limited, because of the current compensation structure in the Office of Ombudsman, we are really, our hands are tied when it comes to competition. Of course, we go out of our way. I've had the opportunity to recruit in the University of the Philippines and in Ateneo. I've delivered recruitment lectures there. We actually competed with Justice Argelesa when he was recruiting for the OSG. But the first thing that young lawyers would always ask, Your Honor, and I'm sad to share this with the Honorable Council, is that first question that will be asked is, how much is your starting pay?
Yeah.
And
A very important question.
yes, Your Honor. And
Okay. So, your PDS shows that you have 4 children
yes, Your Honor.
and your wife is a dentist.
Yes, Your Honor.
I still remember when we first interviewed you that your wife was always with you.
Yes, Your Honor.
Yes. How much do your family and social relationships shape your principles in life and career?
Your Honor, there are 2 things that shape my principles in my career.
Yes.
My faith
Yeah.
and my family. So my short answer, Your Honor, to your question is very much so. My family directly shapes how my career is run, how I view things, and how I will resolve cases, Your Honor, if given the chance to serve in the Supreme Court.
Okay. Independence is one of the attributes
Yes, ma'am.
required by the Constitution
Yes,
for
ma'am.
members of the judiciary.
Yes, ma'am.
Will you please tell us your thoughts on judicial independence?
Yes, Your Honor. Your Honor, I'm a strong advocate of independence as a concept. In fact, Your Honor, in the Office of the Ombudsman, I am a strong advocate for an independent ombudsman. In the Constitution, the phraseology is very clear. Under Article 8, Constitution states that there shall be created an independent ombudsman.
Okay.
So the term there was precisely placed to describe the nature of the office, that for the ombudsman to perform its functions, it has to be independent, free from any form of influence, particularly political influence, Your Honor. But if I may hasten to add, independence does not mean isolation. The Supreme Court will have to work with other stakeholders in the justice sector, and there are other pillars in the justice sector that the Supreme Court will have to work with. But in terms of influence in the way its decisions are being run, particularly political influence, I think the Supreme Court has to be clean and totally immune from these types of influence. And that is my concept, Your Honor, of independence. And our Constitution, Your Honor, has provided for a fairly extensive list of guarantees to ensure that the Supreme Court will be able to really protect its independence, Your Honor.
And how would you reconcile this perception of judicial independence with the Filipino mentality of utang na loob?
Yes, Your Honor.
Utang na loob to anybody
Yes, Your Honor.
who will help him in his appointment or to the appointing authority.
Yes, Your Honor.
How would you reconcile this perception of it?
Yes, Your Honor. In our outreach programs, Your Honor, in the Office of the Ombudsman, I have been asked the same question, maybe phrased in a slightly different way. If it's part of the culture of the Filipinos to be
Yes.
corrupt, because there are such things in our culture.
Utang na loob.
But my answer there, Your Honor, is there's a difference between culture with a big C and culture with a small c. Culture is what makes us beautiful and noble as a country. You know, our family values, our industry, our honesty, and so on and so forth, Your Honor. But culture with a big C is that there are certain habits in our communities, in our society, that would facilitate corruption. And among other things, Your Honor, it would be utang na loob,
Yes.
the patronage system.
Yeah, you are right.
For me, Your Honor, it really would require certain level of political, or in the case of the Supreme Court, judicial will to resist these types of influence, Your Honor. And in the Office of the Ombudsman, Your Honor, we have seen that it can be done. It can be done, Your Honor. In the Office of the Ombudsman, we have totally rejected the notion of gift giving. In the Office of the Ombudsman, we implement a strict gifts policy. All gifts from the outside are sent back, return to sender, as we would call it.
Okay.
Any gifts amongst ourselves, employees, will be recorded in a gift registry as required by the rules.
Okay.
And nothing beyond 500 pesos. So wines like 550, 600 will have to be returned, Your Honor. And I'm sharing this, Your Honor, to communicate with the Honorable Council that it can be done despite these bad habits in our culture, with strong judicial will to resist such. It can be done, Your Honors, as it has been done in the Office of the Ombudsman under the leadership of our current Ombudsman and many other agencies right now in the government, Your Honor.
On that note, I have no more question, and I wish you luck.
Thank you, Your
You
Honor.
work on your case. On the
Yes, Your Honor. Yes, Your
Yeah,
Honor.
because that might affect your chances for
Yes, Your
nomination.
Honor. Yes, Your Honor.
Okay.
Thank you, Your Honor.
Thank you.
Thank you,
Good
Your
luck.
Honor.
No, ito pala isa. Ikaw na. Hindi ko pa tanong. Ikaw na tanong. Ikaw na tanong. Hindi ko na natanong yan.
Thank you so much, Justice Lagman. I have only a couple of questions. This is not my question, by the way. So the question sent to us is, what is your most significant accomplishment as Deputy Ombudsman?
Your Honor, I'm only an official of the Office of the Ombudsman. Whatever I share with the Council, I'm not claiming for myself, but attributing it to the entire office, and particularly our leader, the Ombudsman. But one of the major accomplishments that I think I have, I can think of right now, Your Honor, at the top of my head, is I have contributed to the restoration of public trust and confidence in the Office of the Ombudsman. Early in my term, Your Honor, as Deputy Ombudsman for Luzon, the Ombudsman designated me as chairman of the Internal Affairs Board of the office. This is the internal disciplinary body of the Office of the Ombudsman. I have embraced this role, and together with my colleagues in the Internal Affairs Board, we have embarked on we may call it a cleansing process, where we aggressively investigated and prosecuted corrupt people from within our ranks. Because there is nothing more ironic than corruption in an anti-corruption agency. And that we recognize from the very beginning, Your Honor. So I embraced that role as chairman of the Internal Affairs Board, a position that I still hold today. And as a result of our work over the past 3.5 years, we have dismissed from the service 2 deputy ombudsmen, at least 2 assistant ombudsman, several directors, and many investigators and prosecutors. And in addition to dismissing them from the service, the office has filed cases against them for various corruption offenses, Your Honor, and these cases are now pending and are being aggressively prosecuted. This determined effort, Your Honor, to cleanse the ranks, in my humble opinion, contributed to building the current high level of credibility and trust that the office enjoys with the public, Your Honor. I am happy to share that I have, in my small way, contributed to that, Your Honor, please. That would be something that I consider one of my achievements, Your Honor, please.
This is my only question.
Yes, Your Honor.
Your forte is your experience in the office of the Ombudsman.
Yes, Your Honor.
Did it not ever occur to you to apply with the Court of Appeals, because your experience there will prepare you more for the position of Associate Justice of the Supreme Court?
Yes. Your Honor, please. As I've shared earlier, Your Honor, to apply the Sandigan Bayan, it has occurred to me, but applying in the
Not
Court,
Sandigan Bayan, Court of Appeals.
the Court of Appeals, Your Honor, I did not.
Saying that had you applied there
Yes, Your Honor.
before, with your experience there and your exposure in the office of the Ombudsman, you will be a more effective Associate Justice of the Supreme Court. That's all.
Thank you, Your Honor, please.
Thank you.
Thank you, Your Honor. Permission to leave.
Justice Rosemary, ready for interview. We have been waiting for long. May I request that
Your Honors.
we'll do this very, very fast. May I request Attorney Cayosa to start, please?
Thank you, Madam Chairman. Good afternoon, Justice Kandang.
Yes, ma'am.
This is the 4th time that we are interviewing you. The first time was in 2011, the second 2012, in 2014, and now 2016.
But I'm happy always facing the panel.
Thank you, Justice. And in fact, you were shortlisted before for the position of Associate Justice.
Yes, ma'am.
I have actually no more questions because we have, as I mentioned, unless you might want to inform the JBC of any significant development in your career as a Justice of the Court of Appeals.
Nothing so far because that has been our job. So what we've been doing the same thing all year around, day in, day out. So my stint with the court is a happy one, a fruitful one, and I think a productive one.
I understand that some of the justices are assigned a particular committee. Do you head any committee?
Yeah, I head the Rules Committee of the court.
And what major accomplishment have you done as a...
We have revising the rules with regard to because there are original cases being given to us like this writs of amparo, writs of habeas data, so we are, and the anti-money laundering cases are being thrown to us. We have the first crack of all these things, so we are formulating rules and regulations on this matter.
Justice, may I just ask, who helped you prepare your personal data sheet?
Maybe I did it.
Did you request anyone to encode it for you?
Yes.
Okay. May I just make this observation, and you may want to take it from there, because I noticed that in your previous records, you had a very comprehensive statement of your legal career.
Yeah.
Unfortunately, on page 2 of your personal data sheet, it even states here, Court of Appeals legal assistant.
Oh my God.
So you may want to
Court of Appeals
you may
legal
want to make the
assistant.
necessary corrections in as much as we know
Somewhere
that the
on page 2,
under 21 service record.
service record. Sorry, ma'am.
Okay. Fortunately,
yeah.
Okay. Fortunately, on record we have your previous professional experience, but I suggest that you submit an amended personal data sheet enumerating not only your professional experience but also relevant trainings, especially since should you be shortlisted, this is what is presented before the Office of the President, and it should be a complete and an accurate representation of you as a candidate. So, if I may further suggest that even your involvement as a member of the committee in the Court of Appeals be also indicated.
Yeah, I did my personal data information very brief.
Yes, and because we would like to emphasize that personal data sheets are under oath, so we would want it to be a complete representation of you. That's all, Justice.
Of my career.
Yes.
Yeah, so I will be given time to submit this.
Yes, please do. Perhaps by next week, before
Yes,
the end of next week.
ma'am. Maybe probably because when I submitted this personal data sheet, it was the last day, and then I had to leave for abroad. So I really did not take so much effort in correcting everything. So I only wanted a very brief personal data sheet of myself.
As I mentioned, Justice, that's the only thing that I wanted to bring up.
I will comply, ma'am. I
Thank
will readily comply.
Thank you. And
Thank you for
wish well.
advising me on this.
Yes. Thank you, Justice Gutierrez. I have no other questions.
Thank you so much, Attorney Cayosa. May I request Attorney Mejia?
Thank you. Good afternoon. Justice Kandang, as was mentioned earlier, this is the, fifth time that you're being interviewed?
Yes, sir.
So I will not have any more questions. In fact, I was among those who voted for you in your latest application, so I have no further questions. Good luck.
Thank you, sir. Thank you.
Thank you very much, Attorney Mejia. May I request Attorney Guevara?
Thank you, Madam Chairman. Good afternoon, Justice.
Good afternoon, sir.
I have not interviewed you on any other occasion because it's the first time that I'm sitting here.
Yes,
But
sir.
my interest is certainly not on your performance in your career, because I can see that you have a very remarkable academic and professional career as a judge and now a justice of the Court of Appeals. I'm more interested in some other aspects of your person apart from your career. I always subscribe to the view that an effective worker, an effective professional or judge, for that matter, has a happy personal life as well. Something that balances, something that somehow gives him or her comfort from the stress that he or she gets from the work of resolving cases, etc., etc. And I noticed in your resume, in your personal data sheet, that you have stayed unmarried. Yes, for so many years, and I wonder whether there's a special reason for this. Is this really a matter of choice? Would you care to pardon me if I'm intruding into some personal, but just want to get into a certain point after your answer.
Maybe it's not a matter of choice, because if the right man comes,
Pardon?
I will, if the right man comes, and the proposal will be open for consideration.
That's so nice to hear. But for now, Justice, what other activities do you engage in which somehow balance your professional and career life?
I visit my friends every now and then. I do gardening. I do some readings. I do a lot of cooking. So, and then I always go to the province to take care of the house in Batangas, together with my elder brother, because we're the only ones left here to take care of the house of my parents and grandparents. So that gives pleasure to me. Going to Batangas is a pleasurable thing, especially wala ng traffic. Masyado ng, there is a shortcut way of going to the province, so it doesn't give me tension anymore. So that's all. My life is very simple. At weekends, I see a lot of movies on tapes. So that's how I spend my days alone. It's not actually alone. I have my good friends with me.
So you're not lonely, Justice?
No. You can see in my personality that I am a happy person.
All right. Okay.
I'm happy.
right.
I'm happy the way I am. I have no regrets.
Justice, there's just one opening right now in the Supreme Court, and the Judicial and Bar Council is supposed to submit at least 3 nominees for the position. So apart from yourself, and I suppose that you know who the other candidates are, or the other applicants are for this lone position. Could you please tell us, if you may, at least 2 names which you think should also be included in that shortlist?
Shall I be required to do it? Maybe I don't want to prejudge the decision, preempt the decision of the council on this. So I'd rather not say anything about this.
All right, okay. I respect your answer. Thank you.
Yes, ma'am?
Against your self-interest.
Apart from her.
Maybe I have one in mind, but I would not even want to. I don't want to entertain it that way.
All right, okay. Thank you, Justice.
Anyway, if this is not for me, there is another time next year, another year, another year. I have 6 more years to go in the judiciary, and hopefully, it's destiny if we be appointed to the Supreme Court. So it's God's will if I will be appointed now, next year, year after next.
Okay. Thank you, Justice.
Thank you so much, Attorney Guevara. And now the turn of Justice Lagman, please.
Yeah, thank you very much, Madam Chair. Justice Kandang,
Yes,
good
ma'am.
afternoon. My record shows that we have interviewed you since 2009
Yes, ma'am.
in connection with your application for the Supreme Court, and you have sufficiently established your qualifications during all those 4 interviews, and in fact, I voted for you 4 times
Thank you po.
for your inclusion, so I don't find any reason to further grill you on your qualifications. I wish you luck,
Thank you, ma'am.
Justice Karandang.
Siguro birthday gift niyo sa akin because my birthday will be on Saturday.
Happy birthday.
Happy birthday.
So it calls for a celebration, huh?
It's a simple one. Probably I'll go home to the province.
Thank you so much, Justice Lagman. Well, I have known her for many, many years, being my province mate. So I have only one question.
Yes, sir.
You mentioned a while ago Writ of Amparo, and there are other writs, Writ of Amparo, Writ of Kalikasan, Writ of Habeas Data. What else did Chief Justice Puno?
Those are the major ones.
Yes, those are the, well, there have been allegations on the part of Congress that the court in issuing those writs are actually or is actually legislating. May I have your comment on
It's
this?
not actually legislation because we have to, we have to produce the rules, no? We have to do it by, we have to be, there is no standard yet, standard rules yet. So in promulgating the rules, I don't think we are legislating because, in fact, this is a mandate to the court by the Constitution that we have to institute rules to protect these kinds of rights. So it's not legislation. It is a constitutionally granted the power to the court to issue rules on these matters.
Because according to them, if you read and evaluate Writ of Amparo, Habeas Data, and what is the other one?
Writ of Kalikasan.
Writ of Kalikasan, you will find provisions which are very, very substantive in nature. But, how will you defend this?
I have to come across a complaint on this, that we are overbearing.
Yes. If you have to overturn these allegations, what will your statement be?
Because we are only legislating procedures. We are not legislating. We are not creating substantial rights. We are only protecting substantial rights of citizens. To unlawful intrusion, we have to protect the rights of citizens to have a balanced environment, a safe environment. So this is not legislation. We are not creating rights here. We are protecting rights here. And in protecting rights, we must have procedures. And the court,
Protecting rights, justice is substantive. At any rate, I found a provision in the Constitution. The provision is the Supreme Court under Rule 8.
yes, no?
Article 8, the Supreme Court may issue rules to protect and enforce the constitutional rights of the citizens to issue pleadings, bar matter, etc., etc. So that is, I think, the constitutional basis why Congress did not pursue to question this activity of the Supreme Court. At any rate, thank you very much. Good luck.
Thank you, ma'am. Thank you, Ma'am Cayosa, for reminding me of my inadequacies in my PDS.
And happy birthday.
Thank you for not billing me too much. Salamat po. Am I done?
Okay.